in our ongoing series on the FTC's use of technology and its regulation of technology and the role of economics in doing all of that. We're honored to have Commissioner Wright here today to share his thoughts. He'll be speaking in just a few minutes. I'll then turn things over to my colleague, Geoffrey Manne, Executive Director of the International Center for Law and adapted from testimony he gave earlier this year, laying out his concerns, and then we'll turn to a panel discussion that I'm really proud how the FTC uses economics in consumer protection cases. So let me just, before introducing Commissioner Wright, let me just start by saying that the hashtag for today, the general theme, people may take that as a pejorative term. We don't mean it that way. The FTC, like any agency, like any body of law, is always a work in progress. The FTC itself, of course, has always talked about its understanding of its own authority being an evolutionary process, and we see our project as being part of that. And our purpose is to ask how the FTC works and to try to offer suggestions about how it can do an even better job in striking the right balance in protecting consumers. On the one hand, not over-regulating to prohibit conduct that might actually benefit consumers in ways that are difficult to see today. On the other hand, making sure that it uses its powers effectively to protect consumers from practices that are truly harmful, truly deceptive, and truly unfair. Our working group put out a report last year that asks initial questions about the FTC, this being the 100th year of the FTC's existence. We thought it was an appropriate time to start that discussion, and look forward to having more of you here for events at the Woolly Mammoth Theater as we roll out additional reports in that series. So please stay tuned for those. And again, I invite you to join us on Twitter on the FTC Reform hashtag. I'll be taking questions today. Without any mute your cell phones. Don't turn them off. Feel free to keep tweeting. I'll introduce Commissioner Wright, who was a former colleague of ours, co-founded the International Center for Law and Economics, along with Geoffrey Manne, taught consumer protection, antitrust, law and economics at George Mason Law School, and has been an outstanding voice for analytical rigor on the Commission. He's here today, even though he has a pending case that he might probably not mention today, which is his wife is about to deliver. So congratulations to but thanks for taking the time to do this. He's going to give remarks. We'll take questions from the audience, and then I'll turn things over to Josh. So the role of his, or the title of his talk today is "The Economics of Digital Consumer Protection: One Commissioner's View." Ladies and gentlemen, please join me in thanking Commissioner Wright for joining us. Jeff.
Thank you, Berin, for the introduction. Given that I may get a call any second and run out, the phone is going to stay on. So, in front of me, I begin by saying the things I say are not words that belong to anyone else. Not the Commission, no other commissioners, sometimes not even me, today me. But the views I express are my own and not necessarily those of anyone else. In fact, I tried to work that into the title of the speech in this case because I was the sole dissenter, and it's pretty obvious that the views I express are just mine. So I am very pleased to be here to kick off today's panel, and I'd especially like to thank Berin and Jeff for the invitation to speak, as well as their more general efforts to foster an informed debate about issues relating to technology and consumer protection. The series of programs put together by TechFreedom and by ICLE couldn't be more timely, with the Commission commemorating its centennial, a landmark event that I think on its own merits some introspection, review, and serious discussion. But also today's talk comes at a time when the agency has significantly ramped up its efforts in terms of enforcement and policy in the tech sector. The primary focus of my remarks today will be upon the Commissioner's recent enforcement action and settlement with Apple. As many of you know, it's the sole vote against that enforcement action and issued a dissenting statement. The Commission alleged there that Apple engaged in quote-unquote unfair acts or practices by failing to adequately disclose to parents and other iTunes account holders that they would be billed for in-app purchases that occurred during a 15-minute window that began after entering their password to complete a prior transaction. I dissented from the Commission's issuance of that administrative complaint and consent order because I felt the Commission did not adequately weigh the cost and benefits of Apple's business decisions prior to bringing a case alleging that Apple unfairly failed to obtain express informed consent on its billing platform. You will notice in that sentence, or I hope you did, that my critique in the dissent is largely of the Commission's failure to adequately weigh the cost and benefits of Apple's business practices. I will say now, and I'll say it a couple times in the speech, there is, well, I would normally get to say in most rooms there's no bigger fan of the Bureau of Economics and the agency than me, but Pauline is here, and Howard's here, Marty is here, so I'm like fourth, which is not bad, but I'm a pretty big fan. I'll also briefly comment upon the Commission's recent data broker report. In particular, the data broker report offers cost-benefit analysis more generally, and to provide the analytical foundation for Commission policy recommendations. I included in the report several footnotes highlighting areas where I believe the Commission recommended legislative action and promoted certain industry best practices without first gathering what I would view as the proper evidence required to support such recommendations. That is, evidence that would exceed their. Our remarks today will focus upon my thoughts on the best ways for the Commission to approach unfairness analysis in the digital age, and more specifically, how the Commission should incorporate economic analysis of the cost and benefits of various practices into its consumer protection efforts. And starting this, some history on the evolution of unfairness in the consumer protection context will provide some useful background. Howard doesn't need to listen to any of this because it's largely stuff I learned from reading his papers. The first iteration of the FTC Act, enacted in 1914, contained only a broad prohibition on unfair methods of competition. In these early years, although the agency had the authority to prosecute deceptive marketing practices using the unfair methods of competition prohibition, it was somewhat constrained in that the courts required a showing of some predictable impact on competition or competitors. The Act to include, quote-unquote, unfair or deceptive acts or practices. While the Wheeler-Lay amendments allowed the FTC to pursue deceptive or unfair acts or practices independently, the agency generally lumped the two together, and the two parts were viewed as part of a single standard. That changed in 1964, when in the agency explained the factors underlying an unfair practice in the absence of acts or practices that violated either the antitrust laws on the one hand or the deception authority of the Commission on the other. This standard, sometimes referred to as quote-unquote cigarette rule unfairness, includes an examination of, quote, whether the practice, without necessarily having been previously considered unlawful, offends public policy. Whether the practice is, quote, immoral, unethical, oppressive, or unscrupulous, all terms you should not find in me substantial injury to consumers. This older and relatively unbounded standard gives more weight to vague and unspecified public policy considerations or unscrupulous, and uses a substantial injury. It doesn't consider whether the injury is outweighed by any countervailing benefits to consumers or competition. Because the cigarette rule unfairness standard rejects the consideration of benefits of various business practice, it threatened to chill business conduct that enhances competition or otherwise makes consumers. A significant history with this unbounded unfairness standard. The application of this early articulation of unfairness resulted in a series of rulemakings relying upon broad, based entirely upon the individual commissioner's personal values, and did not have to consider the ultimate cost to consumers of foregoing their ability to choose freely in the marketplace. It was very well said. In fact, it is a quote from Dr. Beales, a couple rows down, describing that era. As others have pointed out, untethered from a rigorous cost-benefit analysis, the early unfairness standard failed to reflect the underlying philosophy that this early unfairness standard, the underlying philosophy that the ultimate objective of consumer protection is to make consumers better off. Ultimately, in the wake of the so-called KidVid controversy in the late 70s, during which the Commission attempted to ban the airing of certain commercials during children's TV programming and was subject to considerable popular and political criticism, the FTC ultimately abandoned this standard in favor of its policy statement on unfairness in 1980. Under this revised standard, and as subsequently codified by Congress in 1994, the agency may cases where an act or practice causes or is likely to cause substantial injury to consumers, which is not reasonably avoidable, by the consumers themselves and not outweighed by countervailing benefits to consumers or competition. In reformulating this unfairness standard, the Commission recognized and utilizing its authority to deem it a rigorous analysis that is necessary when it uses its deception authority. It is also well established that one of the primary benefits of performing a cost-benefit analysis is to ensure that government action does more good than harm. I wrote it, okay. Rigorous economic analysis protects against the risk that business practices that provide consumer net benefits are not erroneously condemned. Cost-benefit analysis is simple and straightforward when the practice being analyzed generates all harm and no benefits. However, nowhere is that risk of condemning consumer welfare increasing business practices or deterring their creation more salient than when, as was the case in Apple in my view, they provide obvious and intuitive consumer benefits. From an institutional perspective, the FTC is remarkably well positioned to carry out the analysis required to ensure that our digital consumer protection efforts do indeed make consumers better off, with an independent Bureau of Economics and many talented economists within its ranks. Before turning to the Apple decision, it's worth exploring a few applications of unfairness that highlight precisely how this authority can be successfully applied in the digital age to reach business. Unfairness authority in the online context under former Chairman Tim Uris in October 2001. In the so-called Cupcake Party case, the Commission alleged that 5,500 copycat or misspelled web addresses to divert Internet users from their intended Internet destinations to one of his sites, and then held them captive while he pelted their screens with a barrage of ads. It was extremely difficult for the website visitors to exit from this programming. Computers would often crash, consumers would lose unsaved work product, or otherwise be deprived of use of their computers. The Commission's complaint alleged two unfairness counts, one for Zuccarini's practice of diverting consumers to his website, and another for the practice of obstructing consumers from subsequently leaving those sites. In retrospect, it may appear obvious or trivial that the conduct at issue qualifies as an unfair act or practice, or that there's not much to learn from this case in terms of potential application to other technologies or business practices in the digital age. I disagree. Putting aside the apparent egregiousness of the actions of the players in Cupcake Party matter, this case is an important illustration of the Commission exercising its unfairness authority only after applying the cost-benefit analysis embodied in and required by Section 5N. Faithful and rigorous application of that look that actually makes consumers better off. While that was not a particularly close call on Cupcake Party, methodology matters a great deal when it comes to unfairness analysis. First, the aberrant code resulted in substantial tangible injury to consumers. Consumers lost work product, the computers crashed, and they were deprived of use of their computers. This injury was also not reasonably avoidable. The defendant specifically targeted unwary misspellers who were unaware of the misery that was about to befall them. Consumers had no way to avoid the economic harm beforehand, and once the code had started running on their computers, they had no way to stop or mitigate the injury. Importantly, there was also no evidence that this unavoidable substantial injury. The Cupcake Party defendants did not attempt to show their practices involved consumer choice or preference, that they had an ongoing relationship with consumers, or even that there was any sort of business justification for their business model at all. Another area in which the Commission frequently has asserted its unfairness authority is in the context of cases alleging unauthorized billing practice. Indeed, the Commission majority describes Apple as a simple unauthorized billing case. The concept that, quote, companies may not charge consumers for purchases that are unauthorized, end quote. While I obviously disagree with that description for reasons I'll discuss in a moment, exploring the application of unfairness in true unauthorized billing cases highlights both how that authority can, when applied appropriately, reach conduct that harms consumers, and illustrates the obvious differences with the allegations in Apple. In Crescent Publishing Group, one of these unauthorized billing cases, the FTC filed a 3-count complaint in federal district court alleging deception as well as the unfair practice of unauthorized billing. The Crescent Publishing defendants operated pornography websites that offered visitors quote-unquote free tours of the content on parts of its sites. In order to take a tour, visitors were required to enter the credit card number. The visitor was assured the card would not be billed during the free tour and told that the credit card number was necessary to verify age. As you might have guessed, despite these representations, many visitors ultimately were charged a monthly membership without their knowledge or consent. In a preliminary injunction hearing, in addition to concluding that the FTC was likely to prevail on its claim that the defendants' representations were deceptive, the court also concluded, after application of the FTC's 3-pronged unfairness test, that the FTC was likely to prevail on its unfairness claims. The court found the consumer to join because the disclosure that they were joining and agreeing to a monthly membership was either the injury was unavoidable was bolstered by the fact that consumers had difficulty in avoiding or reversing defendants' bills. Consumers were also unable to determine who was billing them, what they were being billed for, and how to contest the charges. Furthermore, the defendant's identity was not immediately apparent on the face of the bills because of their practice of billing under various quote-unquote discrete names for billing descriptors. Even the consumers that could track down the defendants were denied refunds. The court concluded that in these circumstances, it's likely that the injury to consumers was substantial in the aggregate. Importantly, the court also considered benefits. While the defendants pointed to the noted that the evidence of chargebacks and credits suggested that they have also deceived many others. In granting the preliminary injunction, the court ultimately concluded that the benefits did not offset the harm caused by the defendants. The court's willingness to conclude that Crescent Publishing's billing practices were unfair was based upon a determination that the defendants were being less than forthright with consumers, that their activities lacked much semblance. They noted that the defendants attempted to disguise their charges on billing statements by using pseudonyms, avoided informing consumers what they are being billed for, engaged in other various behaviors to avoid protection, and constantly denied refunds. Imagine, instead, a company whose priority is to maintain strong relationships with its customer base, its branding, who offers innovative products that consumers clamor for, whose mechanism for initiating purchases is prominent and clear, and provides timely billing as well as refunds. I doubt, that was me describing Apple, in case it wasn't clear, I doubt that in considering such a case, the Crescent Publishing Court, or any other court for that matter, would be as sympathetic to finding the unfairness standard satisfied. Apart from the unauthorized billing cases that are grounded in fraud, the Commission often exercises its unfairness authority in cases where the business practice generates relatively obvious harms and little or no benefit. There, the underlying economic analysis embedded within the unfairness authority is relatively straightforward. For example, I voted for and discussed elsewhere my support for the Commission's exercise of its unfairness authority in a number of cases, including HTC and Aaron's. Now for the not so good news. As you're all aware, this past January, the Commission issued an administrative complaint in Apple that Apple engaged in unfair practices. Because Apple did not expressly inform account 15-minute window during which users could make additional purchases without once again entering the password, the Commission's complaint alleged that Apple billed parents and other iTunes account holders for the activities of children without obtaining express informed consent. I disagreed. In order to deem a practice unfair, recall that the Commission must show that the practice causes consumers, which is not reasonably avoidable by consumers themselves and not outweighed by countervailing benefits to consumers or to competition. This standard calls, I think quite obviously, for an economic analysis of the allegedly unfair business practice. The economic analysis it invites is an appropriately flexible one. incorporating not only the harms to the aggrieved consumers, but also benefits to consumers or competition more generally. The evidence certainly supported a surprise. Many business practices that improve consumer welfare overall are also well understood to harm at least some consumers. The unfairness standard is not a per se rule of illegality for those familiar with the antitrust law, or a strict liability standard. It does not provide the Commission authority to deem a business practice unfair merely because some consumers are injured, or because the Commission can imagine an alternative business method or product design that might make some consumers better off. The Commission must instead conduct a rigorous analysis of the economic harms and benefits of the allegedly unfair practice of the unfairness authority in a manner that can important to understanding my concern with the majority opinion in Apple to understand that I largely agreed with their view of the evidence of consumer harm. There was no substantial disagreement that there was at least some harm to a group of consumers. Nor was there any real disagreement that this was a case involving a minuscule percentage of total Apple consumers, the parents of children who made purchases ostensibly without their authorization or knowledge. The injury in this case subset of consumers. There was also no disagreement that the overwhelming majority of consumers use the very same mechanism to make purchases and that those charges were properly authorized. Indeed, the nature of Apple's disclosures is an important attribute of Apple's platform and affects the demand for and consumer benefits derived from Apple's devices and services. Information is disclosed, passwords required, and passwords are required affects the value of consumers' experiences on Apple's platform. Requiring changes in the design of this attribute of Apple's platform may well make some consumers better off by decreasing the likelihood of consumer harm from unauthorized purchases. However, tinkering reduce the value of the platform for some other users. This trade-off lies at the heart of the economic analysis of information disclosure upon by the Commission involving various unauthorized billing practices. Here, there's simply no dispute that Apple's choices with respect to how it designs its product, including when, where, and how Apple communicates with consumers about billing on the platform for in-app purchases made during the 15-minute window, improve some consumers' experiences and thus enhance the value of Apple's platform and products. Anybody in the room with an iTunes devices knows that the ease with which users can operate the platform affects one's experience. Apple knows that too. And Apple had apparently determined that most consumers do not want to experience excessive disclosures or to be inconvenienced by having to enter their passwords every time they make a purchase. Apple's product design choices, including the nature of these disclosures and its choice to integrate the 15-minute window, are a product of considerable investment and innovation. They provide substantial benefits for those consumers who do not want to experience excessive disclosures or have to enter their passwords every time or more than one time they make a purchase. These product design choices, as I point out in my dissent, implicate economic activity by consumers across Apple's entire platform and not just in-app purchases. Recognize that the overall impact upon consumers from declaring one aspect of Apple's product design unlawful requires analysis of consumer activity across the entire platform, a common situation in software platforms and multi-sided markets generally. It does not require any adjustment in the unfairness standard. It only requires recognition of the simple economic point in the sales of many of its products and devices through that platform are complements. To be clear, the fact that Apple makes its own calculus as to how to weigh the cost and benefits to consumers of its product design decision doesn't mean that it's necessarily done so in a way that shields it from unfairness liability. But the unfairness standard places the burden upon the Commission to show that the harms from those decisions outweigh the benefits. But the Commission offered and relied upon no such evidence. Given the apparent benefits to many consumers and to competition from Apple's allegedly unfair practices, I strongly believe the Commission should have conducted a much more robust analysis to determine whether the injury to this small group of consumers justify the finding of unfairness and imposition of a remedy. Rather than engage in that form of analysis or rely upon it, I felt that the Commission, under the rubric of unfair acts or practices, simply substituted its own judgment for a private firm's decisions as to how to design a product to satisfy as many users as possible, knowing some harm would come to a small group of consumers. But much like for Apple, the fact that the Commission was able to identify some cost to some consumers assign unfairness liability. Indeed, the statute requires consumers count in its own calculus. The methodology adopted by the Commission is problematic and concerning, at least to me, if continued or applied in other contexts. Here, the Commission found complaints about a business practice by a small group of consumers sufficient, without more to establish unfairness. That economic analysis, in my view, is much closer in conceptual spirit to the cigarette rule than to what is required under 5N. That approach is especially from the same business practice. Unfortunately, the consent order required Apple to revamp, in my view, was an otherwise indisputably legitimate business practice without requiring such evidence. Let me shift gears and talk about the data broker report. For similar reasons, I also believe the Commission needs to conduct rigorous empirical work and cost-benefit analysis prior to making not just enforcement. The most recent example is the data broker report issued this past function in getting descriptive data about the industry. Staff was able to obtain some important information about the types of activities in which data brokers are engaging. However, with regard to policy development, this is an area where I believe it's critical to understand the potential outcome of any proposed course of action, specific recommendations. Serious cost-benefit analysis concerning consumers and privacy requires rigorous study of consumer preferences. This is all the more so in the context of broadly applicable policy pronouncements. And what I mean here by serious analysis is to reject the methodology often used in regulatory debates surrounding privacy, according to elicit consumer preferences by asking whether incidence and scope of consumer harms, rather than just speculative hypotheticals about how consumers might be harmed, before regulation aimed at reducing those harms is implemented. Accordingly, the FTC would need to do at least some work, qualitatively or quantitatively, to identify more definitively the incidence or value of the data broker practices to consumers before taking or endorsing any form of regulatory or legislative action. The report itself acknowledges that these practices have some benefits, and that's a start. But it does not take on the step of more thoroughly examining their approximate magnitudes, or the approximate magnitudes of the harms and benefits. We have a lot of work to do on understanding the cost of data broker practices as well. We have no idea what the cost for businesses would be to implement consumer control over any and all of the data shared by data brokers, to what extent these costs would ultimately be passed on to consumers. Once again, the same general principle applies. A critical safeguard to assure against the risk that our recommendations and actions do safeguard against the risk that our recommendations and actions do more harm than good is to require appropriate and thorough cost-benefit analysis before acting. This failure could be especially important where the cost to consumers from complying with any recommendations are high, but where the ultimate benefit generated for consumers is minimal. For example, to effectuate opt-out might be high in certain circumstances, may not offer consumers any real benefit. If consumers have minimal concerns about the sharing of certain types of information, perhaps information that's already publicly available, I think that we should know that before requiring data brokers, or recommending that data brokers alter their practices and expend resources and costs that may be passed on to consumers. Analysis into commission decision making, both with respect to application of unfairness to high-tech markets and more generally. With respect to the former, Apple illustrates many critical lessons, but I'll limit myself to 3. First, as simple as it sounds, the Commission should take seriously the fact that unfairness analysis does not contemplate a rule of strict liability or per se illegality. This is true generally, but nowhere more important than the context of complicated unfairness allegations in high-tech markets. The Commission majority describes the case as merely reinforcing the proposition that companies can't charge consumers for unauthorized purchases. That proposition sounds like one sounding in strict liability to me, but the unfairness analysis must be satisfied with economic evidence and empirical rigor rather than assertion with little or nothing to do with the design of Apple's iPad. Second, cost-benefit analysis in multi-sided markets and software platforms necessitates analysis of harms and benefits on all sides of the market in order to fully understand the impact of the practice upon consumers and competition as required by statute. One-sided economic analysis in multi-sided markets is a recipe for consumer protection policy that does more harm than good. This is especially so in those high-tech and digital markets that are driving economic growth and The economics of information disclosure are fundamentally different when the information to be disclosed is a latent defect that can only harm consumers. Think of the hot fuel geysering in International Harvester as an example. Then when the information dramatically impacts the value of consuming, analysis of the potential harms and benefits must take into account these fundamental differences. More generally, as an economist, I strongly believe in the implementation of thorough cost-benefit analyses across many of the agencies, across the entirety of the agency's consumer protection mission, but particularly when the agency uses the unfairness authority, calculates civil penalties, or makes policy recommendations. To that end, it has been one of my priorities to engage with and work with and try to give more prominence and voice to the Bureau of Economics in evaluating these matters. If I had mentioned in other contexts the unique composition of the agency, housing individuals of competition, consumer protection, and economics, has the potential to facilitate informed and well-reasoned decision-making. And the quality of economists within our Bureau, I think, stands second to none across all regulatory agencies. I continue to look for ways to further integrate economic analysis into the agency's decision-making and policy recommendations, and especially within the realm of consumer protection, where we've had less success with that than on the competition side. Thank you very much for your time, and I am happy to take whatever questions you got. Thank you.
Josh, have you named the baby yet?
I had some ideas during the speech, but I thought Section 5N was like a weird name.
But there will be a cut. Any questions from the audience? Alden Abbott. Do we have a microphone for those in the audience for asking questions? It'll just give us a second here, just for the benefit. If you could just introduce yourself, please.
Certainly. Alden Abbott, Heritage Foundation. Unfairness doesn't seem to sound in cost-benefit analysis. Is there a possibility that greater emphasis on cost-benefit analysis in unfairness would just get the Commission to characterize more cases of deception to avoid cost-benefit analysis? And how do you deal with that? Or do you think reforms are needed to also impose cost-benefit analysis on deception?
Two things. It's a great question. I mean, I think coming from an antitrust background, I think the way that I think about the deception authority is something more akin to per se rules in antitrust. I think it would be a mistake to say, for example, in antitrust, that the per se prohibition on price fixing is devoid of economic analysis. We have some empirical information and some theory that says cartels are always or almost always bad, which I think renders a per se rule or a strict liability rule there appropriate, in part based upon economic analysis. I think in sort of pure deception case and conduct that has no cognizable efficiency benefit, I think that analogy holds. I wouldn't quite call the deception standard as devoid of economic analysis, despite the fact that it doesn't call for a case-by-case cost-benefit analysis. And I think that's probably, in terms of economizing on agency resources, a perfectly fine approach to a dividing line between deception and unfairness. And in fact, to the extent that calling for more rigorous application of a cost-benefit analysis on unfairness substitute case law and deception on what's required and not required in order to establish misrepresentations. That's an area of the law in which I think judges are perfectly. It's the unbounded nature of adopting something like a cigarette rule style of unfairness that I think is a little bit more of a regulatory risk, because precisely because it's unbounded.
Tom.
Do you have any more specific suggestions about how to get economic analysis and cost-benefit analysis more involved in privacy and other consumer protection issues?
You know, I think that the main it's always struck me, and those on the panel will probably more informative than mine in terms of how to face this challenge. But I think one of the reasons why economic analysis has been so wholly integrated on the competition side is because the antitrust laws from the late 60s to current have at every corner demanded committing malpractice if they came into a modern antitrust litigation without economic evidence. I think the law changing there have been other important things too, including innovations within the agency and so forth, guidelines that the agencies have produced. There have been other contributing factors, but I think the Supreme Court's sort of revolution of the antitrust law is really what is motivating that change. Leaves a little bit of a puzzle on the consumer protection side, because here you've got a statute that says, hey, do some cost-benefit analysis. But I think that the culture inside the agency on the consumer protection side and competition side, how much economics should be driving the bus, so to speak, is quite different. And I think there is, no doubt to me whatsoever that we've got the capacity in the agency to do all of the work that needs to be done. In fact, really the problem that I think is key, and you'll notice in the speech I try to focus on decision making is what I view as the problem, not the capacity to do the analysis. I think on the antitrust side and on the competition side, the fear of losing cases in court because the law changes is what induced people's willingness to talk to their friendly neighborhood economist and rely upon his judgment in deciding what cases to bring. I think that maybe that needs to happen on the consumer protection side too. But I think openly talking about some of these issues, this is I do also like to hear myself talk and read myself when I write, but the main reason to write dissents is for me to try to call attention and get some of that discussion to happen, and I'm hopeful that it will do so.
Josh, I just can't resist asking, so to the extent that it's not economics and that it's not litigation and the courts, what is driving the bus in consumer protection cases?
That's a good question. So a couple things. In cases, I think I don't know what the percentage is, but I can count the number of dissents with, I think I need two hands now, but I'm voting in large part cases. There are important economic debates in these cases over remedy, and we've had, I think, varying degrees of success in having economic input context. But in terms of case selection, the priorities are shifting around into, for example, areas like privacy or cases like Apple. I shall not name the other one. But I think those are priorities that come from the chair's office and from the heads of the bureaus. And I think that those shifts have been, from where I sit, I certainly followed what the agency was doing under the last chair pretty close. I think that there have been some modest shifts from Chairman Leibowitz to the current agenda, but nothing that I would describe as dramatic. I do think, Apple certainly is in my view a case of first impression and a shift that we shouldn't have taken. But these are priorities that are set. Upstairs from me, one floor.
Josh, on the cost-benefit analysis in Apple, what's really the cost here? As a consumer receives notices all the time and clicks through them, I mean, what's really the burden on Apple here, and how does it, really, it just has to provide better notice?
So I'm a little hamstrung in answering this. They certainly had an answer. They certainly had an answer for that, and I'm not going to. As you might imagine, a company designing a platform where its interaction with consumers is sort of the main driver of success thinks long and hard about precisely how it designs the platform and to make it easy for consumers to use. You take web experiences for example. I mean, just a little bit of latency on a website drives a tremendous amount of traffic away. And people think long and hard and spend billions of dollars trying to avoid it, precisely because consumers have other choices for other platforms to use. Now, there is a really interesting issue about separating out liability and remedy here. One of the interesting arguments that I've heard in response it's related to your question, in response to my dissent is, yes, but what's in the remedy really wasn't a big deal. We just asked them to, they could have satisfied it any number of ways. They don't have to have a password every time there's an in-app purchase. What's wrong with us playing with their platform a little bit? We have an idea that we think will be profitable, also by which I mean under law you're required to for 20 years. Separating out liability from remedy here is, I think, important. Before we start saying how much would it cost to comply with the order, we should ask whether we've met the initial standard of saying what are the benefits of this practice relative to other options, and what are the harms that have arisen from this practice. Now, that is where I think, do I think that the remedy is going to cause iPads to fall from the sky? No, I don't think that. I think they'll figure out some way to work around it for the next 20 years, and we'll see how many iPads are used, and by the time the order's up. But in terms of the first instance, getting the liability question right, I think it's pretty easy to conceptualize what the benefits are, right? Not having to put in, I know, is a benefit to some users, and it doesn't take a large amount. The number, I point these numbers out in the dissent, the number of consumers that were complaining is a tiny number, right? So we're talking about relative proportions of people benefited and harmed from the practices. Say you think 2% of users, Apple tells them to do, okay, and 2% complain because they they're getting their coffee in the morning card, and they hand it to their child, and they go away to get their morning cup of coffee, and the child runs up a bunch of charges. Okay? A very small number of people did that and complained about it, and the number was shrinking over time because, of course, Apple tries to correct it. And if you think also 98% of the world doesn't care, but equivalently small number of people say, goodness, it annoys me and irritates me, and the password additional times to have to go through additional screens or what have you. You have the answer is that the harm outweighs the benefits, but it
take the prerogative and ask one final question if there's no I wanted to kind of follow up on Tom's question a little bit and ask the extent to which you thought that the use of consent decrees in the consumer protection cases was perhaps driving some of the relative paucity of economics there, given that there isn't a constant reminder from the courts that economics is appropriate to the enforcement actions they're undertaking. And before you answer, I'll just say one thing. This also should be added to your list of benefits of dissenting. Because one of the great benefits of having a dissent, Apple's a great example of this, is whatever is lacking in those is with your dissents anyway made up for by your dissents that go into a lot more detail, and of course force the commission, the majority in the commission, to go into a lot more detail as well. You just don't see that. I mean, you can see a palpable difference between cases in which you've dissented and which you haven't. So let me put in a plug for that as a benefit of dissenting as well.
So I think that the answer to Tom's question, I think they're related, right? And one of the reasons why you see so many, you are negotiating and consents in the shadow of the law and the threat of litigation. And this, on the antitrust side, if the threat of litigation is, I don't think you have credible evidence to prove anti-competitive effect, that is a real threat. Plaintiffs, including the agencies, lose cases like this in federal court when they don't have economic evidence. I think that is, decoupling what the consent negotiations look like and what the state of the law is very difficult to do, because, one provides the backdrop for the others. This is a long way of sort of agreeing. I think the puzzle is, in terms of how the agency treats consents internally, is, the competition side, why a firm with a merger who has a billion-dollar merger wants to divestiture to get the thing through the agency and get done is willing to sign a consent. It makes more important having economic. We don't have judicial review. More important having cost-benefit analysis done within, in order to be able to say there's reason to believe in the public interest, right? To me, the public interest is a cost-benefit. I think having economic input in, sometimes on the competition side, there's a shot clock from the Hart-Scott-Rodino Act that makes that difficult. Not impossible. Sometimes there are real constraints that make it difficult to have a sort of fulsome economic analysis before the clock runs out. In conduct investigations, that's certainly not the case. And other types of issues that have been vetted through the agency for decades, it is certainly not the case. But I think that really is one of the key challenges, is getting agency buy-in from commissioners through the bureaus that integrating economic analysis into the consent process is something that is not just good to do when convenient, but is critical.
Okay. Well, Josh, thank you for coming. Please join. While we're doing our little segue here, I just can't help but reference my favorite Annie Hall line on the subject. That well, really, I heard that commentary and dissent had merged, and they formed dysentery. Anyone? Well, anyway, on the subject of Annie and Woody Allen references in general, I give you Josh Wright. Excuse me. Oh, I'm sorry. The poor man's Josh Wright,
right,
as he often refers to himself, Geoff Manne.
That's right. Thanks, Berin. Well, in keeping with that, something like what we can learn from Josh Wright at the FTC, I'm going to amplify a lot of what Josh said, and I'll try to hit on some points that he missed, and hopefully those will provide also some setup for the discussion we're going to have. His role in technology regulation, and as Berin and I have termed it, the Federal Trade Commission is becoming, for better or for worse, something more like the Federal Technology Commission. And technology creates special problems for regulators. In particular, of course, it evolves. It's not always apparent, always know exactly what the consequences, both good and bad, are of new tech. How to craft law that's flexible enough to accommodate that, but not arbitrary. It's an inherently, I believe, and as Section 5, as Josh discussed, for one, incorporates an economic and error cost analysis that's required. True in evolving and novel areas like privacy and data security, and in those areas in particular, business generally succeeds or fails by trial and error more than through some kind of theoretical. Particularly important source of a cost of over-regulation here. It risks impairing experimentation in exactly those areas where we want more experimentation, which is in many ways an essential driver of economic progress. So, but these problems arise more in the realm of than elsewhere, and commensurately, most, if not many, of the FTC's most significant recent cases are technology-related cases, right? So not only do we have these background concerns, but they are becoming more and more important as the FTC takes on more and more cases that relate to at least these novel, innovative areas that I'm calling technology. Excuse me. So, and as we just discussed, in particular in the questions there, in consumer protection law, unlike in antitrust, I think we've increasingly seen actions being shaped largely by the FTC's without a lot to rein it in, and in particular, we aren't seeing that kind of evolution through judicial review or dialogue with economic scholarship that we see on the antitrust side of the house, and for reasons I've just mentioned, I think that's probably problematic. So the paper discusses several of these issues and where they've come up in the FTC, both on the competition side and on the consumer protection side. And I just want to focus on two of them here, one that Josh didn't discuss and amplifying one that he did discuss, and then leading into the panel. The first one is the case that he said it's the Amazon case. Now, it's pending before the court right now, which is why Josh and Marty and others won't be able to talk about it, but I'm not so constrained. In the last decade, the FTC, to address these sort of cutting-edge issues, including things like online technology related, I think Josh actually suggested this too. The issue here is not that the FTC always gets it wrong by any stretch. The FTC may very well be right in any particular case, but overall what evolves when it engages in these cases isn't law. It's merely a list of assertions as to what the Commission thinks companies should and shouldn't do, and I would argue that's exactly what they did in the Apple case and are doing again in the Amazon case. So what's particularly notable about the Amazon case, like the Apple case, is the unique relevance of the attributes of the conduct at issue to the product. Right? This isn't the cramming case. And I think that point that Josh also made is really important. It's not like you can just dismiss the benefits of the action at issue here, because at least Apple, at least Amazon, and at least a lot of people who purchase their products seem to think it does have value. Nobody thinks cramming has value. This is a very different beast. Unlike in those past and allegedly similar and cited as precedent cramming sorts of cases, Amazon's conduct wasn't aimed at deceiving consumers, nor was it merely incidental to its product offering. And Exhibit A in that is, of course, its one-click concept, which consumers seem to value, which it, of course, patented as well, is obviously important to Amazon's business. And I think it's fair to say that it's implemented doing as much as possible to the design choice of one click, but nevertheless taking account of the sorts of issues raised by in-app purchases. But they're making a trade-off, right? And they are clearly valuing the benefits of minimizing the number of clicks. They are clearly valuing that at something above zero. Moreover, I think it's important to point out that Amazon has implemented this comprehensive parental control regime, including the ability to turn off all in-app purchases, called Kindle Free Time. If any of you have kids and have a Kindle, you know that this thing is like better than sliced bread, right? It arguably goes beyond anything the FTC required in its Apple consent order. Anything it suggests might be in the Amazon, and yet it seems very much like the FTC has a kind of myopic vision of what's appropriate for dealing with this particular in-app purchase problem, and Kindle Free Time isn't it. Although someone else, including the designers at Amazon, would probably beg to differ. I would certainly beg to differ and suggest that the FTC should be looking at creative, novel solutions to these sorts of problems instead of ruling them out by taking a fairly myopic focus and not sufficiently weighing the cost and benefits. All right, in order to keep this a little bit shorter, I would say look at the paper. I have some more discussion of Amazon there, excuse me, and in particular the problems that the FTC might run into when they actually have to go to court and deal with the fact that in their complaint they really only address the harms and they really don't do much to address the benefits, but also the other prongs of Section 5 that they need to address, including reasonable avoidance and countervailing benefits. All right. Role in data security and privacy cases. As many of you know, we're now up to 57 or so UDAP enforcement actions over the last decade around data security. And through these, the FTC has policed how American companies protect user data. Initially, the Commission used this standard only in deception cases. Excuse me. Since 2005, however, the FTC has expanded its approach to cases in which the company made no security promise, essentially collapsing these unfairness elements, the substantial injury, countervailing benefit, reasonable avoidance elements, into this reasonableness of the data security approach, which in turn has largely, if not explicitly, been defined almost entirely by the data security standards promulgated by the FTC under the safeguards rule, dealing with financial institutions. That doesn't mean they're not potentially appropriate elsewhere, but that's really what has happened. We've sort of collapsed all of the unfairness, all of what might have been required under Section 5 to the safeguards rule, which was promulgated in a different context. Again, maybe it's applicable elsewhere, but we should at least acknowledge that that's what's going on. An experience suggests the FTC is moving a lot more toward another, also like in the Apple case, a sort of strict liability regime and away. I've been cut off. The reasonableness of security precautions ex ante on sensible economic grounds, and making that assessment without first developing or explaining the elements of unfairness in a rigorous way. So, as some demonstration of this, a recent empirical paper that I and some of my colleagues at ICLE have worked on. A couple of things that I will just point to, some characteristics of the FTC's data security cases. They're considerably shorter, about 3 pages, than complaints in private causes of action. They're often, if not generally, lacking in detail about causation. They lack any citation or application of precedent. They obfuscate who was injured and whether injuries might have been mitigated. They fail to assert any facts on reasonable avoidance, countervailing benefits, or materiality. And they assert formulaic and conclusory causes of action which might very well not survive a Twombly motion to dismiss. This is potentially a worthwhile trade-off for administrability or even predictability or something else, but that's what is in fact going on with the FTC's cases, and it's very hard to it's even harder to see any ongoing. So I think I've spoken enough, although like Josh, I like to hear myself talk, and I certainly like to see myself in print, so I have 50 pages or so written on this that should be available on both the TechFreedom and ICLE websites if it isn't already, and SSRN, and we'll probably, because I'm anxious to hear what the panel has to say, and turn things back over to Berin and the panelists. Thanks very much.
Thanks, Jeff. That was remarkably indeed. Let me introduce our panel without too much ado. Just taking it down along the line here from Jeff. We're honored to have Marty Gaynor, who's been director of the FTC's Bureau of Economics since September of last year. He's been a professor at Carnegie Mellon University, where he teaches economics. Howard Beales, sitting to run the FTC's Bureau of Consumer Protection. Josh mentioned his extensive work on the history of unfairness, and I encourage everybody here to read his piece on the rise and fall and resurrection of unfairness. He's also been a professor of economics at GW's Business School since 1988. To his right, your left, Pauline Ippolito, former deputy director of the Bureau of Economics, also served as acting director, 30-year veteran of the FTC, and I didn't know this existed, but earned a presidential again, I've never heard of. That's particularly impressive, and she has been at the FTC speak a little more freely than perhaps Marty can, but obviously she and Marty can't comment on everything that's happened at the agency. We understand that. James Cooper, former deputy director and acting director at the FTC's Office of Policy Planning, currently director of research and policy at the Law and Economics Center at George Mason School of Law. And last but not least, David Balto, former deputy assistant director of the same the Office of Policy and Evaluation, and now has his own law firm. So this is a really extraordinary group of experts to weigh here together today. I didn't total up the number of years that they spent together at the FTC or in total, but it would be quite impressive. And indeed, we might get up to something somewhat approaching the FTC's own anniversary this year, which itself is monumental. And it's a great testament to all of your experience. So without further ado, let me just ask you, just to kick things off, just for your quick general thoughts, and I'll open this up to everybody. What is the role of economics in consumer protection, and how should we learn from the role that economics has played in competition cases? And Marty, since you run the Bureau of Economics, I think only fair for me to let you start.
And the second thing I guess I have to say is the usual caveat that everything I say represents my views alone, and not necessarily those of the Federal Trade Commission or any of the individual commissioners. But thanks for putting on this event, and thanks for the opportunity to speak here. It's kind of like almost a preview of a 100th anniversary celebration, Old Home Week. Second, for all of you who are fans of economics, like Commissioner Wright, there are those foam #1 hands by the door, but they're invisible, so you're going to have to look hard for those. Things. One, economics does play a very important and critical role at the agency, and I understand from what people are saying, sometimes that's not completely evident. It may be a little opaque, and we heard some discussion of what some of the reasons might be for that. But typically the way things happen is a case comes up or a matter comes up, and this is true in parallel both on competition and consumer protections. Our case here, consumer protection, and the Bureau of Economics start looking at the matter, and they're communicating very closely with one another. And ultimately, if this thing is going to have some legs, both the Legal Bureau and the Bureau of Economics do independent analyses, which are written up in internal memos and make their way up to the Commission. And that's a very brief synopsis. There's a lot of interaction at all levels back and forth on that. But an important thing, and this touches upon something that Josh said, is the agency is particularly, I don't know if unique exactly, but a particular feature is that there is an independent Bureau of Economics at the agency, and one of the key roles of the Bureau is to do an independent, careful economic analysis of all the matters that come up and get that in front of the commissioners so they have that to weigh along with the legal analyses. I'll stop there, and certainly anybody else on this panel can add to that, either to expand.
Is there anything like this anywhere else in the government? Does any other agency have a Bureau of Economics?
Well, sorry.
Yes.
Yeah. I mean, it's not completely unique, but I'd say that that having an independent bureau is a very important feature, and there are other parts of the government where that's certainly not the case. Where, say, there are agencies where there are certainly economists, but those economists answer to lawyers, and it's a very different organizational structure.
I'm already being a little too modest. As far as I know, it's really the preeminent think tank, if you will, inside the government for doing economic research, and that's certainly shown through very clearly in competition cases.
Pick up your foam hand.
Indeed. As a former veteran of that bureau.
You know, one of the things to recognize is that on the consumer protection side, there are many, many more cases than there are on the competition side. And many of them are fraud cases or very simple cases that the economic staff doesn't devote a lot of attention to. I mean, we help with the evidence, we help put facts together and all of that, but once we determine that, yes, this is indeed a fraud or something similar to a fraud, we don't spend our resources there. Where economics becomes important is in these bigger policy cases, where through the cases you're effectively setting consumer policy. That's where you want the commissioners to have a discussion. You want them to think harder about what should they be doing, why should they be doing it, what's the right trade-off, what are the alternatives, are there simpler remedies? That's where, ideally, the economists play a bigger role. I guess I'll do my pitch for data here, since some of you deal with have clients. The economics becomes much more salient when we have evidence to put in front of the commissioners. When we're doing theory against anecdote, anecdote wins. We have children who charge $300 without their parent even knowing it. How can that be good? And then, oh, there's some theoretical cost somewhere. That's much less persuasive than when we have evidence on how frequent is the problem, how big is this subpopulation within the universe of users, what's the time trend look like, having that kind of evidence helps the commissioners, who are very busy people. You know, they've got to make a lot of decisions, but it really helps them to see the issues. And so, you know, it really is important to good policy making that we have data and evidence to put before the commissioners.
For both an economist and a former director of the Bureau of Consumer Protection, what was your experience?
I think in some ways the place where the Bureau of Economics has the greatest influence on what the Commission does in the long run. There are some incredibly valuable studies in the economics of information that Pauline did, looking at changes in the regulatory environment and their impact on consumers. There was a very influential study on rent-to-own transactions and their impact on consumers. I mean, that kind of research is exceedingly useful in shaping what should be the consumer protection priorities. I mean, I've always thought about any consumer protection case from a cost-benefit perspective. As Pauline says, the fraud ones are easy, and that is a good chunk of the workload, and arguably should be a larger chunk of the workload than it sometimes is. But it is difficult in emerging areas to get good data. And you know, that limits what the economists can do, and the influence that they can have on the nature of the decisions that are made.
Please.
Howard's point is an important one, but particularly in this day and age, firms are increasingly report, but that's just one example of these kinds of things. And so I think we're often in situations where, at least in principle, there are quite a lot of data that can be available to the economists to analyze to help really get a better picture of what's going on, either as a general research issue or, as Pauline mentioned, in a particular case. So I think often we're going to be in a stronger position in terms of availability of data than we may have been in some matters in the past.
You've been involved in policy planning, working on both the competition and consumer protection side of the aisle. What difference do you see between how the Commission works might learn from the Bureau of Competition?
Well, just to kind of echo, I guess, some of the themes that were in Josh's Commissioner Wright's speech, and Pauline was saying, is I do think that there's definitely kind of a sliding scale in the need for economics in consumer protection. So, you think about consumer protection cases could be broken down. I mean, there's fraud, and there are clearly no benefits, and mapping that into probably proper to call that per se. Then you get into an area of, like, say, growth negligence. Maybe that's choice point, things like that, where, okay, we don't really need as tough analysis there, but when we get into the issues that are present in, say, Apple and HTC and Amazon, we're looking at a business practice, and the FTC is saying, well, this business practice has some sort of error rate, or it's harming some consumers, and we think you could make it better. Well, there we're getting into, I think the analogy would be maybe a little more like, if we're analogizing this to antitrust, be a little more like Section 2, where we're looking at unilateral conduct. And Section 2 case law, as we know in antitrust, as with the economic revolution, and it's really difficult to bring a Section 2 case. The burden on the plaintiff is quite substantial because of competitive unilateral behavior. Like Apple, like Amazon, that is more economic analysis. I think that's where it could be useful, in the case law. And I think also, again, echoing what I think all the panelists have said so far, it's in the broader policy areas, say like the privacy report, the data broker, the recent data broker report, that have so much influence in the community. I mean, it's using the bully pulpit. It's saying, here are the things telegraphing, here are the things we think you should be doing. Make a promise that you're going to do those things, then we can sue you for deception, right? So those, to the extent that these broader policy pronouncements are going to impact a large portion of industry going forward. I mean, think about, digressing a tad, but think about Facebook's recent purchase of WhatsApp. Okay, easily cleared on the competition side, but there was a stern letter from the director of the Bureau of Consumer Protection. Hey, Facebook, you're under order. Watch out. No, you can't tell me that. Watch out on how you use WhatsApp's data. You can't tell me that the value of WhatsApp's data was not somehow part of this merger between the two. And here's the FTC saying, well, for the next 20 years, you're going to have to think very carefully, and you're going to be very circumscribed in the way you can where if you're going to have that kind of impact on the economy, that's where you really need the economic analysis.
I want to unpack some of what you just said, but I also want to give David just a chance to weigh in with his initial opening thoughts.
Yeah, I agree with a lot of what people say, and I want to applaud the FTC's economic research role, because I think that can really help educate people here. Look, from my perspective as a consumer advocate, there are a lot of chronic problems in the digital marketplace. The FTC fortunately has a broad range of tools that it uses flexibly and hopefully in a judicious fashion to go after these things. And I sort of wonder at the end of the day, if the FTC had not brought an enforcement action here, or didn't bring an enforcement action against Amazon, what exactly would happen? Would there be bad practices that would continue? And that would trouble me as a consumer advocate. You're not going to, after you've been to a product to some other product. And I think the FTC, I don't think there's a disagreement about what the unfairness standard is when you look at the statement of the Commission and Commissioner Wright, and he is to be applauded for issuing the dissent to create this dialogue. But it's a question of whether or not they agree about whether the costs outweigh the benefits. And I think the Commission has the better of the statement that the costs here are really not substantial. But I think what the Commission needs to do is look at its broad range of tools, and in doing that, I would agree with the other panelists that the economists can play a more significant role.
David, given the chance that the Commission might get it wrong, what is the marginal benefit of the Commission intervening? Say in the example that you cite of Amazon, given that there are, of course, state attorney generals that can bring action, that private lawsuits can happen, and then the market, in fact, can work. Where do you think
I disagree with that. I actually think, looking from the consumer's perspective, there are relatively few tools. Bringing an individual consumer class action is really tremendously difficult under the current standards. Aren't as active, and I think probably everybody in this room would like to have a federal agency do it, especially one where there was sort of a balanced cost-benefit analysis that was part of the equation.
I just want to respond to something David has said. I mean, about the. I think letting the market work. We look at Amazon and we say, okay, I think you'd said something about, well, there are these complaints and consumers are kind of locked in, so they can't do anything about it. Maybe Amazon and Apple say, so what? But is a zero consumer complaint where the market needs to go? So is that evidence the market doesn't work if some consumers complain about a product? And then going back to the Section 2 or antitrust analogy, in antitrust we don't regulate prices. We don't care, hey, the price is too high, so we're going to bring a Section 2 case. We can't do that. Is that in a way kind of the same thing here? So Apple has this policy, Amazon has this policy. Some consumers don't like it, and the FTC thinks we should be down at a zero complaint rate or close to a zero complaint rate. 3% is too high. In a way, if that could this be looked at as evidence of Apple or Amazon using a little bit of their market power, which on the antitrust side we don't really care about unless it's illegal or gained illegal or exclusionary. Here's just okay, well, we please 97% of our customers. We're not going to go any further.
Well, yeah, there's a little bit of this debate within the statements in the Apple case, but as a consumer advocate, I making its prudent judgment about what a significant number of complaints are, and those certainly seem to be the case in both Apple and Amazon.
Putting here that, of course, we're talking about initial complaints, and those people were reimbursed. So there are layers of response here, and the question isn't just, as James put it, well, what's the right number of complaints? It's the right number of how much hassle for consumers, whether the chances that first or never notices. So they're ever smaller numbers. And Josh's point was you have to weigh those against the benefits, and the Commission seemed quite willing to aggregate disparate harms, but not willing to aggregate small benefits that might incur to consumers.
Berin, one point that the Commission makes that I think is appropriate is not everybody's going to complain. May chalk it up to experience. So.
I want to get back to Pauline's question about evidence. So evidence is great, but what you do with evidence depends on what your methodology is, and it also depends on seeing what good work actually happens inside the bureau. So let's just step back and remember that comparison that James was offering with competition cases, where in competition cases we know we get case law, we get the courts developing methodology, and so we know what evidence actually does inside the black box on consumer protection. However involved the Bureau of Economics is, it's hard to say from the outside. So just give us a sense, Pauline, please, of how you see that issue.
I think this is one of the real challenges in the consumer protection area, and it goes both ways. Apple, because we had data, the case that Apple, began as is not at all the case it ended as. Okay, but none of that is visible to any of you. And I can't say anything more specific than that. But the debate at the commission level, Josh's concerns, Maureen's concerns, the evidence that we put before them, produced a very different outcome than was the initial proposal. That's completely invisible to the business community, completely invisible to people who have to make real decisions as they design the platforms and figure out what the regulatory risks are. And I think that's one of the reasons I like having a contrarian on the commission at the moment, that threat of public discussion forces everyone to crystallize their positions, to be much clearer in their own heads as well as to the public as to what they're doing and why, and what they're not doing and why. If you read Maureen's dissent, and she didn't dissent, but she talks about some of the things that the commission didn't do. For instance, they didn't hold Apple liable from the day the platform went live. Real evidence at Apple, we knew that from the data we had, that there were problems. And then Apple responded, and the commission judged that to be an insufficient response. But this was a new technology. To all be anticipated. The issue for the commission in the end was, how did they respond once they knew they had serious problems in this particular area? So, you know, I don't think that, unless you read very carefully, it's hard to see that. The fact that we had all these statements, public statements from the commissioners, made it more visible. That's not typical. And that, I think, is one of the real challenges on the consumer protection side. Unless they're a fraudster who have, you know, they're just buying time until they're shut down, nobody goes to court on the consumer protection side, almost nobody. And so you don't have the opportunity to see the evidence, to see both sides, lay out the positions, and then get a judgment at the end. It also goes the other way. We have a lot of good cases. General policy, I think, are terrible. You know, in an ad, so they don't have substantiation for what they say. There's no question it's a good case. And then we put them under a fencing-in order that says you must have 2 clinical trials of this type with this data, and so on and so forth. And the only thing the advertisers see is what is the commission putting out in its consents as a likely standard, a guidance for what they should have before they make a claim. Well, it's very hard internally when you have a clear case. It's a good case. We all agree, economists and lawyers, it's a good case. It's hard to get the commission to really focus on what's in the consent and what. It's a real challenge.
I'll ask the same question for everybody else, but given what you mentioned, that the commission brings a much larger number of consumer protection cases, and we probably don't want to make those generally more difficult. How do we get the commission to explain its analysis better in the cases that set law?
Well, I think the having a contrarian on the commission is good. I think the age of public comment is something that the agency doesn't use as much as it could or should, in my opinion. And I'm speaking only for myself, not anybody else. You know, I think it is a real challenge. Speeches from the commissioners are the other way they would say. I think the interest they have in trying to push certain areas at the same time, you know, you're all here because of the move into the technology area and the mobile platforms in particular. In some ways, start thinking more of policy. What should the policy be in this area rather than individual case. And getting them to think at that level is important to communicating and to developing good policy.
Marty, we can't put you on the spot about particular cases, of course, and that's the very problem. We don't know what happens inside. So what can your office and the Bureau of Consumer Protection do to work more closely together and to explain how they work to folks on the outside?
First, let me echo what Pauline said last. I think an important role for the Bureau of Economics, and I won't speak for the Bureau of Consumer Protection, but Howard can certainly weigh in on things, at least during his tenure there, is to raise these broad issues. And we've heard a bunch of them already, right? First question economists ask is, will the market take care of it, right? It's the answer to how many economists does it take to screw in a light bulb? None. The market will take care of it, right? So that's the first kind of question we ask, was brought up by a number of. We bring those issues. We can bring up issues about technology and rapidly changing conditions, and try and get those on the radar screens of commissioners to start them thinking if they're internal. As far as external, I don't know that I have anything in particular to add. We certainly can do research, and that research can be out in the public eye. There's a lot of stuff that we do with the Office of Policy and Planning on the competition side, consumer protection side. That stuff often can be very useful. It's relatively quick turnaround and response to really direct and important manner. So that's another possible, I think, outlet for these kinds of things.
I want to go to David, but before I do, Marty, are there internal ways just to get the Bureau of Economics more engaged? For example, making sure that economists in your bureau get to look at the cases that BCP brings, even if BE decides not to weigh in on them, at least being able to identify those cases where there might be a real issue of economics raised that wouldn't be visible to attorneys in the Bureau of Consumer Protection, that kind of internal process thing.
Sure. Well, I mean, BE is actively involved. As Pauline said, there's a very large volume of cases, and I don't think it's sufficient to have simple fraud cases where somebody crawls out one side of a rock and they come to our attention and they get beaten down, and then a few months later crawl out the other side. Outside of sort of damages assessments, I don't know that it's a good use of resources to have economists working on those kinds of things. So there has to be some triage there and some discussion. But I think when certainly it's an important kind of matter, like the kind of things we've been talking about here, where there are important issues, then inevitably the Bureau of Economics is involved.
That is certainly consistent with my experience. I mean, there's inevitably this process, something that will sometimes go amiss. There'll be a case that raises an issue that the economists see that the attorneys don't. But most of the time, I think it works pretty well, and it certainly is the efficient resource use. I mean, in my tenure, there was probably too much, not enough to the bigger picture questions that are or the main value added of the Bureau of Economics. So I think, and I do think there's more that can be done externally in the way of giving guidance about how the Commission is thinking about things. One is the analysis to aid public comment that Pauline mentioned. That's apparently a very informative document on the competition side about what the Commission is thinking. Many of you know, and he's always after me to go look at the analysis to aid public comment on the consumer protection cases to understand what's going on, and I keep telling him there's nothing there. On the competition side, so maybe there's leverage there. In the data security area in particular, there was for a while a practice of writing closing letters and putting them on the public case against somebody. That It isn't clear why, but that seems like a useful practice that that can give some more information about what the thinking is about what exactly was a problem and what's not.
I just wanted to, again, I'm sort of troubled about what happens if you didn't bring an enforcement action against Apple. And look, you have companies that legitimately want to obey the law. They want to know what the law is. And I think if the commission sort of recognizes that there is a problem, you know, it has a wide variety of tools. Let's go and do some kind of workshop. Economists talk about some of the the Apple case, and through that workshop process, perhaps you're going to do as much as bring in enforcement action. I hear complaints, and I think they're legitimate, especially in the data security area, that just sort of setting regulations by case adjudication, especially when it's just consent orders, which are strongly criticized in Jeff's paper, that's a weak way of trying to sort of to sort of weed out bad practices.
I didn't insist, but I will now that you've given me the opportunity. So, David, you said something like you're troubled by what would happen if the FTC didn't have an action against Apple. I'm troubled by the implication that there's something so problematic here that the world would collapse if 17 people didn't have stronger incentive to, as Josh suggested, treat their iPhone like a credit card that it actually is. And Pauline has referred to this evidence that was presented. I think Josh suggested that the evidence of benefits is hard to calculate. But I'm troubled by the implication that it's appropriate to count the benefits at zero. In real trouble if the FTC didn't bring an action against Apple and now Amazon, which is even more puzzling to me.
Well, to be better notification, and Apple attempted to do things. They didn't change things in a fashion that really fully protected consumers. And remember, what we're talking about, and nobody said it yet, is we're talking about vulnerable children. I mean, children who so.
Talking about vulnerable children, right here, the alleged harm was to parents' wallets. And their vulnerable children were not the ones who were at risk. It was the parents, right? Yes, of course. I mean, as we all know, that's how this works. So, we don't have to keep debating this, or we can come back to this, and it doesn't take away from the points you were making. But it's important to point out this is not a COPPA type case. This is not about vulnerable children. This is about parents who have to save for college and are instead paying for Angry Birds.
Berin, Berin, I just wanted to. I guess I want to switch. I know we got back into talking about Apple, but your question that Howard and Pauline were addressing, and Marty as well, about the general policy about the role of economics and how it be. In my experience, when I was there in the Office of Policy Planning, we're the big, and I also was at the commission level, and my experience at the commission level with the small cases was very much that so many of these are just run-of-the-mill fraud cases, some guy selling fake pills out of his station wagon or whatever, and do you need an or his website station? I'm back in the '80s, station wagon website, but anyway, do you need an economist to figure that out? No, but where I saw a huge difference, and this is when I was in the Office of Policy Planning. One of our probably our biggest missions was to do reports. So we did a lot of reports, and all the reports that we did, wine report, we did a report on postal, we did a report on real estate, we all worked hand in glove with the Bureau of Economics. Okay, it was done with them. They approved it. If they thought we were doing something, we had to have their approval, not just because we ultimately needed the director of the Bureau of Economics to sign off on the memo going up to the commission to approve it, but we really wanted experience with, say, the privacy report, and not in the building for the data broker report, is that BCP reports are done differently. Now, I don't know, and this may be a reflection of, policy planning was primarily, we're mostly all competition attorneys, so we're used to that marrying up of the law and economics, and it comes from antitrust, whereas BCP is, there is not the marrying up of the law and the economics there. So what you end up with is reports that are done through workshops where, rather than data, you have anecdotes, and it goes back to what Pauline says. So you have Jeff Chester said X on this panel, or Mark Rottenberg said Y on this panel about privacy, and then so and so from industry, from social media company Y said this, and so we took all this together, and here are our recommendations. The Bureau of Economics, to my knowledge, at least, again, I was in the building for the first report and part of the drafting of the second report that came out. They were not inside baseball. I mean, I know in the commissioner's office, the first report, we had to affirmatively fight, maybe fight's too strong a word, to actually get some cites to the extant, very small extant economic literature that's out there on the trade-offs in privacy. We actually had to, we'd send it back down and it would come back redlined out. I'm like, wait, we wanted this back in. So I think that is reports are done on the competition side versus the consumer protection side. And that's where, and I haven't been in the building for 3 years, so I don't know if it's changed, but to the extent that policy, especially in the privacy and data security area, is coming out of reports, that's where the economists should really, really be engaged. I think that's where their value add. Trading order. That has nothing to do with anything else.
I will say I have plates in both of my wrists, and the only metal detectors on the entire planet that have ever set them off are at the Federal Trade Commission, which I take to and I've traveled extensively, and I take this to be just a sign that the Commission maybe overcalibrates for risk. So let me just ask about reports here. What should the role of reports be? I mean, Pauline, for example, you talked about the importance of evidence in cases. How do you think that the Commission should use reports, and how should it go about policy making, whether it's recommending practices to businesses or making the case to Congress for new legislative authority?
I'm a fan of, you don't have data to address every question. Where you have data, where you find the right opportunities to really test in terms of the economists going in and documenting, you changed policy, here were the worries ahead of time, the trade-offs we were worried about, how did it play out, and really documenting what happened. Those are very valuable studies, so I agree with everybody who said that. But those opportunities don't come along all that frequently. These kind of workshop reports, to me, I find them less persuasive than they could be. They gather people from all sides of the issue. They report that there's a big disagreement about what optimal policy looks like, and then they make suggestions. I wouldn't find that it has value, because a lot of people up on the Hill have time only to read well, what are they suggesting? And should we put that in legislation? But I think the Commission should be striving for. I think there ought to be a more solid foundation if we're going to be making recommendations on legislation, certainly, and even best practices. I mean, the government as management consultant makes me nervous.
So, given how many great economists there are over at the Bureau of Economics, what do you think the Commission should be striving for in its reports? What do you think would be the kind of report that the Commission should feel proud of analytically?
Well, I'm an analyst, so I like to stick to an analytical base of what are the issues, What evidence do we have? Unfortunately, in a lot of these areas, we don't have a lot of hard evidence. And so it makes it hard to make very concrete recommendations. And if that's the goal, I'm not going to be very useful. And so sometimes the economists are not invited to participate.
No cupcake party for you.
None.
Well, Howard.
I think there probably should be more role of economists in shaping some of the workshop to data have the opportunity to present it. I'm not sure that always happens in the workshop process. But it is, it is the opportunity. And I think it's really important to engage on those questions, even when there's not the kind of evidence we'd like. What troubles me about a lot of the recent reports in particular, what the Commission has authority to do and the way it would like to see the world work. And where it's and what I think it's very consciously trying to do is to pressure people to do things that it understands it cannot require. And I think that's sort of very problematic where it's done with sometimes a very explicit threat of things that can be enforced and others can't. And what's not.
I don't mean to imply also that some of these descriptive reports in and of themselves are not valuable. I mean, if it's a brand new area, the very fact of pulling together the people who have different perspectives on what the issues are, doing a thoughtful discussion of the issues of the critics and the proponents, and just making that available to the world, I think that can be a very valuable thing. What's uncomfortable is doing that and then tacking on legislative recommendations or tacking on best business practices. If that hasn't been the focus of the descriptive report, I don't know how you get from A to B. But I really don't want to say the Commission is struggling to figure out how the old consumer protection principles that are well established move into this new world. On its face, the idea that people should be notified before they build is a pretty good concept. You know, it helps make contracts work, helps make markets work. It's how, when, how much, you know, how, in what form. That's where it gets tricky. But
Pauline, I think we all find great value in the workshops that the Commission produces in describing issues and in hearing from people about what's really going on, what the challenges in consumer protection are. But I find it also a little troubling that there's more focus on anecdote than evidence, but also that there's very little discussion. In fact, there seems to be a concerted effort to avoid discussing the FTC's legal authority, the doctrines that it's applying, the existing laws that already are in place. And for example, just curious for all of you, Commissioner Wright did not issue a concurrence or a dissent on the data broker report, but he did have a number of footnotes inserted that explained his concerns. And among them was the fact that the things that the Commission talked about needing new legislative authority are already covered. The example that the Commission led with, that it put in its press release at the very top, was the example of a motorcyclist getting, on the one hand, ads about motorcycling, not problematic, but also perhaps being discriminated against in insurance eligibility. That is certainly very troubling, but the Commission didn't mention that's already covered by the Commission's own interpretations of Fair Credit Reporting Act, and various other laws cover many of the issues that are raised about lending and housing discrimination and so on. So there seem to be two concerns there. There's on the one hand, or maybe three. One is about anecdote versus for new legislative authority without really why new legislative authority might work better. And then the third is essentially establishing those reports as de facto law. and turning around and enforcing them. And certainly the Commission has in its LabMD and Wyndham proceedings, has pointed back to workshops and reports that it's issued in the past as if those were duties, stating duties that companies had to follow. So anybody have any thoughts on reports and workshops and what the Commission should and shouldn't be doing with those before we move on? David?
I can't imagine that the Commission citing its own report is going to be all that persuasive to a federal judge as to what the law is. I think, the judge is going to want to know what other courts have decided. So
well, funny you should mention that. What have other courts decided? Well, of course, the answer is not much. So let me use this to pivot the conversation, David, if I may, which is, of course, the FTC has been bringing consumer protection actions related to new. It moved into privacy cases and then into data security cases around the turn of the millennium. And we're starting to see new product design cases, and we don't have any clear case law to point to. In the Apple case, the majority cites to a few cases with no explanation in their footnote. It's not exactly clear how they're on point. But this is really uncharted law, and Josh's dissent is valuable because it starts to replicate some of that, but not much of it. So my question for the panel is, what will it take to actually get some clarity here on to David's point, what is and what isn't good enough? Is it just litigation? And if so, are there ways to encourage that? And if that's not going to happen, what can the Commission be doing to produce more of that clarification of its own doctrines? That's a stumper.
Yeah.
Well, I think we've talked about other than the things we've talked about, it's not clear what the Commission can do, or people to fight with the FTC. But no, that's
well. Then Howard,
hard to tell a client. You ought to spend lots of money on attorneys fighting. And that's why it doesn't happen. It has to be important enough to be worth fighting about.
But anybody want to suggest why that is so rare compared to competition cases? Is it just the PR?
Huge body of outside law that constrains what they do. You know what price fixing is. You know what it's not. There's some cutting edge cases in Section 2. But for the most part, there's no outside constraint for unfairness. Place where there could be in deception, I guess some of the First Amendment reins them in a little bit. A lot of the commercial speech, that came about in the 70s and 80s, Goldfarb, Virginia Board of Pharmacy, Central Hudson. That sort of reins in cabins deception a little bit. But there's nothing that cabins unfairness from the outside. And like Howard said, you have a client, you can say, there's a huge public good aspect to litigating and getting a clear rule. Do you say, okay, now just take the consent for 20 years, it's no big deal? Or do you say, yeah, let's litigate this all the way to the Supreme Court or, to the 4th Circuit or 11th Circuit? I guess with LabMD, maybe that's a bet of course, they're out of business, right? So someone else is taking that on, and I don't know. Clarifying the law, but I just think it is this conundrum. We'd like to have law, but there's no, and I would hate to. I guess I will be on record saying this, but in some ways, the antitrust with a private right of action, you end up with this great body of case law out there. That constrains the Federal Trade Commission. There's no private right of action under Section 5. Now, I'm not suggesting there are a lot of cons with having a private right of action under Section 5 that probably far outweigh the pros, but I think that's the central, it's kind of a catch-22 here.
But let me just ask you about two other sources of discipline we haven't talked about. Well, one is external discipline from the media. So, for example, the Washington Post had this to say. This is to David's point, and I'm quoting here from an editorial. But what are the children to be protected from? The FTC's proposal, in reality, is designed to protect children from the weaknesses of their parents, and the parents from the wailing insistence of their children. that traditionally is one of the roles of a governess, if you can afford one. It is not the proper role of government. And of course, if that doesn't ring a bell, it's because that is the long forgotten but recently uncovered 1978 editorial by the Washington Post that about the FTC being a national nanny. And this is my way of just reminding everybody here that on the one hand, there was a moment when the FTC, to Howard and Josh's point, went much too far with the cigarette rule version of unfairness. And there was a moment when a Democratic Congress did intervene, provided an external constraint, asked the agency to rulemaking, and set the FTC on a course that. And now we're seeing the FTC, as it's struggling to deal with its doctrines in new areas of law, is starting to raise some of the same concerns. So my first question is, what should we learn from the experience of the 1970s when the FTC's legitimacy was called into question?
Here. One of the things that the agency has done relatively well is that they haven't gone that far out on anything. Reasonable people can disagree about Apple, but in the end, what did they do? They said, hey, we're not going to tell you how. Make sure that people have notice that when they put in their password, there's a 15-minute window. That's what they said. You know, that's not an outrageous thing. Apple is going to deal with it. They're getting there. Whether we needed it or not, whether it's going to do a lot of good or not, it's not something that really is way out there. In order to get people to fight, I think you need 3 activist commissioners who have plans. Then you'll get a commission that goes to occasionally. Yes, yes.
Any other thoughts on what we should learn from the experience of the 70s?
I think one of the threats to the commission going forward is that there are very few people left at the commission who went through that trauma in the 1970s, and the people who have been through it are universally more cautious about expansive notions of unfairness and more sensitive to what are the costs and the benefits than the people who say, no, the people who think I can make this up. And none of the history, and sort of thinks it can.
Be time for Congress to consider whether, having asked its use of rulemaking, whether maybe it's time to look at how the agency operates generally and why it is that the Commission's. I mean, the unfairness policy statement does specifically talk about the Commission's expectation that unfairness would develop over time through the courts. That hasn't happened. It's worth asking either why, or if that's not going to happen, what can be done to make sure that the Commission substitutes for some of that analytical development. So are there things that Congress can do that are constructive and would be bipartisan?
Hearing by the House Oversight Committee, 2 hours and 45 minutes. If you figured there was a place to pillage and burn the FTC, this was the place. And it was titled the FTC Jury. You know, sounded to me like the place where it would happen, but at the end of the day, they seemed to reach a consensus that the FTC, you know, there were problems in a certain case, but you know, the FTC's Section 5 powers seem to be, you know, not something they wanted to.
I think there were a number of legitimate questions raised about fair notice and how the agency works, and we'll see what comes of that. Any other thoughts before we move to questions from the audience?
One thing to remember here is we're having very rapid technological change. Consumers don't know what they're doing. They're getting caught by this technological change. There is, in a sense, a demand for what the agency is doing. You know, being the cop on the beat, sort of watching what's going on and trying to push firms to do better. The agency doesn't get a lot of heat when it goes to the Hill. I mean, there is a demand for this. That said, you know, the Commission's job is to do that well. And that's, you know, and most of the time they do. The vast majority of the time they do. It's just as we get into these more technological areas, it's harder to know what is, you know, what the right policy is, and they're struggling with it a bit, I think.
Echo something Pauline said, and actually come back to something I said earlier. I think there are roughly two key questions to ask. One, and I think in this area, without commenting on any specific matter at all, I think there are some real question marks. There are some reasons to think that the market may not. I don't want to suggest that. Question marks there. Economic theory is far from clear on that, although again, I think there are some reasons to at least be concerned. Two, with regard to cost-benefit analysis, one of the key parts of unfairness, certainly from the economics perspective, one of the key parts of that is deciding in a reasonable fashion, a principled fashion, how broad the base is. So, who are the groups of consumers who benefit? Who are the group upon whom costs are imposed? One, it's very difficult, really impossible to do that without thinking, at least in some sense, about what the remedy may be. It doesn't necessarily have to be exact, but you have to have some sense of what the remedy may be. And two, I don't think there's a clear, bright line on that. But you could end up in different places. The closest analog I can think of is the question about market delineation on the competition side, which is still with us to some degree. And there, once you make a decision often about where the market boundary is, the rest often flows from there. So that's very. With regard to Apple, you had 3 different statements from the 4 commissioners on there, and certainly Josh's statement lays out his take on the economic issues very clearly and completely. But you can see that, I think, in the statements from the other commissioners. I think they all fully written up, and you don't have a full economic analysis in all of the statements. But I think you can see these things coming up, and they're coming down in different places on them. But I do think that you do see these issues being raised and being grappled with by the Commission.
Take questions from the audience if anybody has one or two. Right back here. Please, just go ahead.
A very elegant solution to what many regarded as the second coming of the children's advertising rule, this being the interagency working group proposal to prohibit advertising of most foods to kids, did not gain the Washington Post editorial that the 1978 Washington Post gave, but it died a very similar death. Congress came out and said, Federal Trade Commission, be further with this rule until you have conducted a cost-benefit analysis showing that the rule actually a guide would improve the. We actually heard statements from some of the officials at the commission at the time saying we couldn't possibly conduct such a cost-benefit analysis. So I think a very simple rule would be to ask the commission to give more information when the case is decided that says, here is how we analyze this order and how we believe this order will improve the operation of the marketplace over the status quo. I'm not sure the Apple order would do that. At least I don't know it would. Thing right now would never be these orders of the way the marketplace will be operating 15 years. That would be a useful exercise for the commission to undertake.
So I'll just distill that for the live audience. So first question is there a problem without a clear remedy? And the second question is, shouldn't the commission have to establish not quick responses, lightning round here?
It also raises the issue of the 20 years. I mean, the commission's posture these days is all orders are 20-year orders. In an area of rapid technological change, it makes everyone a bit nervous. Now, to their defense, they have tried to stay away from engineered solutions because of this, the knowledge that everything is changing. But another margin is, do orders have to be 20-year orders?
No. Along those lines, in competition cases in high-tech areas, the orders are certainly less than 20 years. I think Intel was something like 5 or 7 years. So, and for something as complicated, yeah, I bet you processors will look pretty much the same way 5 to 7 years from now. I can't imagine that Apple's, billing practices are going to look like what they look like today 3 years from now.
Let me put the question another way to the panel. Again, this is lightning round. Might it be that as we look back on this period, say in 20 years, that the isn't the Apple case or the HTC case necessarily, but the Google Safari case? That is to say, could it be the case that the commission ends up even further bypassing the analysis that it does today by just saying, hey, whatever you did, however simple it was, whether it was material or not, you violated a consent decree, and that becomes the de facto basis for regulating the technology field. James?
No, I think that's a real fear, and I brought up, mentioned before, I think in earlier remarks, the complementary pairing of assets in the future that we couldn't even imagine now. And so you've got a startup now, and then your Facebook or your Google, and you want to take that startup and make or Twitter. I guess everyone's under a 20-year order. You want to use that data to make an even better product that we can't even imagine now. But now, oh wait, I have to remember that I'm going to have to get express consent because they're going to become part of Facebook. So now I have to get express consent if I'm going to use the WhatsApp data, and I'm going to have some real difficulties in mingling this data from the FTC front and get approval with them. That can really, businesses are structured, can have big ripple effects going forward, I think.
Well, we're out of time here, so I'm just going to go down the panel and just ask you just to give your 3 suggestions on concrete, constructive suggestions. You may have already said them. That's okay if you want to repeat yourself. But what can the commission be doing even better than it does today? And David, if you want to start.
The process more robust. So if you look at the public comments, Josh wrote this great dissent. So where are the public comments for 30 days? There are 43 consumers who filed public comments basically saying they were happy or unhappy. Now the most interesting comment, no organizations apparently filed. I listed his organization as parent and grandparent, and this is what he said, and Berin will love this. Government gone amok. If my kids order apps without my permission, I, the parent, deals with the order and my kids. How are kids going to learn or parents teach them if some bozo from Washington steps in and interposes his or her views? Lord help us. Plus, I make sure this doesn't happen in my house. Well, that wasn't a meaningful answer to your question, but I thought this comment needed to be made.
I now owe you $20 afterwards for reading that.
I confess, right? David, that was me. I wrote.
Briefly here, because we are over time.
I don't have three. I just say one. I just more use of economics and data where it's available in all BCP reports.
Pauline, with microphone.
The Commission face do more to articulate the basis for their decisions, the thoughtful decisions on these bigger cases for the public to absorb.
Howard?
I think more explanation would be extremely useful. It can be done in lots of different ways, in analysis to aid public comment, in speeches after the fact, in dissents, to try to explain as much as possible about what's going on.
Research to provide better, stronger evidence in cases, basic research to enhance our fundamental understanding of what's of the report process to inform our understanding of what we're actually seeing going on out there in the world.
Jeff?
Agree with all of that. In particular, more explanation to go along, and assuming, of course, that it actually incorporates economic methodology and economic analysis of evidence. That's what's needed, and we need to see more of it, not just have it happening in the background.
Well, stay tuned for more from both TechFreedom and the International Center for Law and Economics, and our working group of distinguished experts who are listed on the back of the report that you'll find outside on this issue this fall. We'll put Josh's speech and Jeff's paper up online as well. And I'll just give a plug to the FTC. There's a workshop coming up on September 15th about what to do about the discrimination communities. For one, I'm delighted to hear the FTC is actually returning to a harm-based framework, having decided that they weren't going to. They're apparently doing that, and that's all for the best. And the FTC, of course, turns 100 on September 28th. Its anniversary gala is November 7th. I'll be there. I'll be expecting those one-finger thingies to be given away at the outside. And of course, stay tuned. The Third Circuit yesterday just announced that it would hear Wyndham's appeal. So we are actually going to get some more development of case law in this area. I'm excited for that. Looking forward to answering some more of these questions, perhaps here at the Woolly Mammoth Theater in the months to come. So thank you all for coming. You can find more about our work on TechFreedom and laweconcenter.org. Thank you.